I've got it. Okay, thank you. I'll be ready to start. Well, good morning, everyone. My name is Caroline Marshall, and I'm a staff attorney with Legal Aid of Southeast and Central Ohio. I'm based in the New Philadelphia office. I'm really excited to be speaking with you all today about our reentry work and a little bit of the background of our program generally. Yeah, like I was mentioning, please bear with me as I work with technology. I'm not a product of my generation, unfortunately. I'm pretty bad with technology, and this is actually my first presentation on Zoom, so I'll be working with that. I also don't know if I can see hands or anything like that, so if you have questions, please come off mute or whatever you need to do to flag me down at any point. I'm cool with interruptions. Stop me at any time. With that said, I'll start with a quick look at our agenda here. We'll be discussing who we are as a recently rebranded LASCO, colloquially known as Legal Aid. We'll go into record sealing and expungement, CQEs and CQHs, and then driver's licenses. Who we are, LASCO, formerly known as SOLS or LASC respectively. We combined recently in the last couple years, became Legal Aid of Southeast and Central Ohio. We are 8 offices spanning 36 Ohio counties, those of which you can see here on the next slide. As I mentioned previously, I'm in the New Philadelphia office, which is here shown in purple. My office covers Tuscarawas, Carroll, Holmes, Coshocton, and Guernsey counties within our service population. And we cover anything in the colors. So a good chunk of the state is what LASCO covers. To qualify for our services, clients need to meet a number of eligibility requirements, and we lay those out in the next couple slides. So I'll go through those kind of individually, but they're kind of listed here. And we go through these at our intake level at the start when clients come to us for representation. Generally, for income, we look at household income at or below 150 to 200% of the federal poverty level to qualify for our services. This can vary a little bit from county to county. It just depends on what kind of the issues are too. We also will look at the assets of that household at or below $15,000. These kind of become a puzzle to see how clients will qualify. We ask a number of questions to kind of get what the assets are for the family. And again, it does depend on where you're located. Clients generally should be U.S. citizens, but we can also represent lawful permanent residents. And if you do have documented asylum or refugee status, we can accept non-residents or those without legal status if they self-identify as victims of domestic violence or human trafficking, so long as those individuals are coming to us for legal issues pertaining to those issues. An example of this would be if someone's coming to us for representation for a civil protection order and are identifying as someone as a victim of domestic violence and are a non-citizen resident, we could consider them under the immigrant eligibility exception, so long as they also meet our other eligibility requirements that we have started discussing, but I'll continue to go into detail for those as well. It wouldn't just be a one and done in that circumstance. Unfortunately, we cannot represent for clients who are solely here for student visas or work visas. We are also limited or restricted from accepting clients for reasons of conflict of interest. This means if we are already representing someone who's on the other side of that case or something along those lines, we may be restricted from accepting them for that reason. We also consider local issues of priority. That can be a number of different things, kind of looking at the capacity of attorneys in that office at any given time. This can also be the case types that we're prioritizing at that time. For an example that we always like to make people aware of is we always prioritize domestic violence instances to ensure that clients are always in a safe situation. And these are kind of generally the overarching types of cases that we take. We're not going into too many of these today. We kind of touched on domestic a little bit with protection orders, but mainly today we're going to talk about reentry work. I can say generally, I'm a generalist, so I practice in all of these in my day-to-day practice. Reentry. When we talk about reentry services at Legal Aid or at LASCO here, we are the types of things we help with, and we'll go into each of these a little more on the next slides. Before I move on about or away from just our general information about LASCO, anybody have any questions? If not, that's totally fine. We're just going to get into more of the nitty-gritty for record sealing at this time.
Carolyn, will you be
Yes.
sending your slides after the presentation?
I definitely can. Yeah, I can share them
Okay.
with you guys.
Thank you.
I know I'm going quick, so I'm a
Thanks.
fast talker.
You're good.
Yeah, I'll share them out. I can get them to, I think Cassie's been our contact, but I can share them to whoever wants them. No questions. I'll go forward though. A quick disclaimer I have to make is I cannot provide specific legal advice as a part of this presentation. I can provide general legal information, and if you're interested in speaking with an attorney about the specifics of your case or a client's case that you may have or someone you know, you can call our intake line. That number is 888-246-4420, and I'll provide that again at the end of this presentation so you'll have it. And again, we'll send the slides out so you'll have it there too. There's no need for me to really paraphrase the information on record sealing, the impact of that. So I'll just read these next couple slides here. 1 in 6 Ohioans have criminal conviction. Nearly 1 in 3 Ohio adults have a criminal record, and Ohio incarcerates 5 Black people to every 1 white person. %90 of employers and 80% of landlords use background checks of some kind to screen applicants. Having anything come up on those background checks, regardless of what that may be, can still have some limitations on housing and employment in some circumstances, and that may not necessarily be disclosed to the applicant. 1 in 4 in Ohio jobs is blocked or restricted for those with criminal convictions altogether, and those jobs may pay roughly $4,700 more per year on average. The difference between record sealing and expungement. A sealed record is a record filed in a separate secure location. This is good for a number of things and can bypass some background checks. But for higher level screenings, it would still be visible. An expunged record is completely destroyed, deleted, and erased, except for in very certain circumstances. It really is what you expect it to be. We're talking about high level stuff that it would be visible on. In order to apply for record sealing or expungement of a criminal charge or conviction, certain eligibility requirements have to be met. To be eligible, you must have no pending criminal charges. This includes traffic charges. There can be no active warrants, and you cannot be on any form of probation, community control, post-release control, and including non-reporting. So this is kind of the chart to look at when we're looking at wait times after final discharge. For each degree of conviction, there's a required wait time for after final discharge before they become eligible for sealing or expungement. For dismissals and acquittals, there's no wait time before those charges become eligible because they're not convictions and they don't need to remain on your record. The final discharge. This occurs in the waiting period. Clock starts at the completion of all incarceration, probation, and community control terms of the conviction. This would also include any payment of fines and restitution required. This doesn't include court costs. That can be confusing for some people if the money owed is related to just kind of the administration of the case. That's not included. If the money owed is related to the conviction or restitution to the victim, that is included. So related to actually the penalties of the crime would be. And we try to separate that out if we're advising clients. Convictions that cannot be sealed or expunged are first and second degree felonies of any kind, most traffic and motor vehicle convictions, felony offenses of violence, and there's a list of these that we keep on hand to make clear for people. And there's a pretty good brochure that's created for this that I can circulate if people are wanting that as well. Sex offenses, when the offender is subject to a reporting requirement. So if you're added to the registry, those would be excluded. And offenses where the victim are under the age of 13. Domestic violence offenses, but there's an exception for misdemeanors level 3 and 4. Those can be sealed. And then violations of a protection order cannot be expunged, but they can also be sealed. All acquittals can be expunged and all dismissals can be sealed. Only charges where convictions can be expunged can those dismissals be of that charge be expunged. And we have a couple of examples of this so that it's easy to demonstrate it. So for a petty theft conviction, that can be expunged. So a petty theft dismissal can be expunged, but an aggravated arson conviction cannot be expunged. So the dismissal of an aggravated arson cannot be expunged. It is eligible for sealing though. Does that kind of make sense? For third degree felonies, this one's a little tricky. Third degree felonies cannot be sealed or expunged if a person has 2 or more other felonies of any degree, or 2 other third degree felonies and 2 misdemeanors of and any other convictions. So it's a kind of a puzzle in this circumstance. That's why it's really important to make sure that we've tracked down any other possible convictions for someone's criminal record. They don't have to all be from the same court or county. When we're asking people about where they've lived, it's important that we've tracked all of that so that we're really kind of piecing it together. Something may come up when the court's looking at their record. So we want to make sure that we have everything before making these applications. Courts don't like to be, or we don't want to be surprised when we've submitted an application and something else has come up and they now no longer meet the requirements that we thought they had before. Attempts. Attempt convictions are treated the same as a conviction of that offense for sealing purposes. That's kind of all you need to know about attempts. If it's an attempted robbery, this is the same as robbery for the purposes of sealing. It's just kind of how they're viewed. It doesn't mean the same thing, obviously, for the conviction itself, but it does for sealing. For traffic offenses, any dismissals can be sealed. Violations of some like local traffic laws can be expunged. Otherwise, pretty much any traffic convictions tend to not be eligible for sealing or expungement. That's why we hear that speeding, OVIs, physical controls, those are not typically eligible. Bound over cases. Cases that are bound over from municipal court to the common pleas court, they will appear on the common pleas expungement application. So that's the appropriate court to apply in. Once the common pleas case has been sealed or expunged in that court, it will also be out of the municipal court as well. So you don't have to apply in both cases. For the hearings, Court's supposed to set an oral hearing within 90 days of filing for a record sealing application. In these hearings, the court will look at the pending criminal charges if there are any, but we've already reviewed that. There shouldn't be any. They will see if there are any objections from the prosecutor. These should already be filed. You should know about these ahead of time. They're not always filed, but they should be. They'll weigh the interests of the state in keeping the record against the applicants, the interest of the state versus the applicant's interest in having them sealed, and they'll consider the rehabilitation of the applicant. It's kind of a pros and cons list that they go through. The application for the sealing, yeah, really does not include much. It's kind of just a really simple form. It just kind of lists the charges, and that's about it. We pretty much always advise that clients additionally submit a personal statement with their application so that their interests and rehabilitation efforts are documented. And so the judge has that to review. This also can be beneficial because we've seen in some local courts that oral hearings are not always scheduled. So in those circumstances, that personal statement can also act, it can also act as a request for an oral hearing. And if one is still not set, at least the court has the applicant's words to consider that if they have nothing else. As I've mentioned previously, the court's looking for a number of things at the hearing. First, they'll look for the evidence the application or that the applicant has been rehabilitated. They will want to hear about any counseling efforts, any anger management, parenting classes, any work that they've done towards dissociating with the people or taking them out of the situation that put them towards committing that crime in the first place. The court will also want to hear about the applicant's reasons for wanting their record seal. They'll want to know the reasons for if they've had lost job opportunities or education opportunities, if they want to be a better role model for their children, or if it will open up other opportunities for them. Really, the court's looking for reasons for why they're applying now. And the more specific you can be or the applicant can be, the better. This is not the time or the place to relitigate the offense itself. The court's really just looking for strides of improvement. And that's the best that the applicant can do to prove that this is the right next step for them. Okay. Before we move on to alternatives, are there any questions on record sealing itself?
When I talked to Mike when we were setting this up, he said that there is a lot of steps that need to be taken prior to even considering it, things that case managers can work on with their clients, which is pretty much why everyone joined us today. Can you give us some specific things that case managers can do to get their clients prepared to even begin to talk to you or another attorney or anything like that?
Yeah, so I think he didn't tell me specifically what he meant by that. I would say what he probably means by that is the counseling is a lot of the work. I think if the charges that they're working through needed any sort of substance use counseling or mental health counseling or treatment, that's a lot of work that can be done. If they need any sort of like assistance setting up work opportunities or education resources or anything like that, those are all good things that they can have lined up to show the court that they have made progress for their lives. The court really does look for that. Those are all things that can help the court to say, hey, they really are in a different place than they were then, and they're not going to be repeat offenders. So those are really good ways for you guys to assist. And then for the application kind of itself, it can help even if they're like looking for ways to create these personal statements. If you're assisting them with kind of getting themselves organized in that, if you guys are in a position to assist with that, you can do that. Because it doesn't just have to be like, that's not an attorney thing necessarily. Because Does that kind of answer your question?
Yeah, and where would someone go? Do they not get the application until they meet with legal aid or an attorney, or is that something that a case manager can get online and kind of look over and navigate through to see what they can help with prior
Yeah.
to even connecting them with an attorney?
Yep, they're available on our website. They're available through the courts. Yeah, you guys can have access to them ahead of time too. The application is really simple. Um, yeah, you guys can look through them so you know what they're looking at as well. Any other questions?
Yeah, I have a question. Where do intervention in lieu of conviction, where does that fit into all this?
That would probably be on the front end. So all of that would be probably prior to conviction. Hopefully they're not having to go through any of this at that point.
So if they complete everything for the intervention, then they don't need to seal or expunge their record, correct?
They shouldn't. It may, unless it remains on the record as a dismissed charge. If it's on there as a dismissed charge in lieu of conviction, then they may still have to. And at that point, then it would go under as a dismissed, and they would do the sealing application for that.
Thank you.
No problem. Any others? Okay. So some alternatives. Human trafficking expungement. This is an available option for victims of human trafficking. This option no longer requires that the conviction be for solicitation, loitering to engage in solicitation, or for prostitution. That used to be the requirement that it was only for those charges. There's a fly. There's some limitations for the types of offenses that can be expunged under this option, but it's greatly expanded since then. This option would only allow for the expungement of charges resulting from the trafficking itself, but it cannot be used for obviously aggravated murder, or rape. There is no waiting period to apply, but it does not help to be, it does help to be off of any probation or community control conditions. So you would have to have completed the terms of the conviction before you can start that application, but you don't have to wait any time after that. Certificates of qualification for employment. This can help remove employment-related collateral consequences. This is an option for any type of conviction, and the wait time is 6 months for misdemeanors and 1 year for felonies or after federal discharge. You can seal and expunge some cases, but still need a CQE for other convictions that do not qualify for sealing or expungement. So if you're kind of going through the record and there's some that are not eligible, you can still kind of do this and still seal some. Kind of does still continue to open some doors for people. When, for example, if someone has a possession of felony or a possession of drugs felony, but they also have a felony assault charge that's not eligible for sealing, they could do a CQE for just that assault charge, but seal the possession of felon or the possession charge. Generally, when applying for a CQE, you must apply the court with a specific job or industry at the time. So it's nice to kind of know what they're trying to get into. They may even have a kind of job lined up, or if they had a professional license before, that can help. Yeah, having prior qualifications can really be a help or a resource there. We see this a lot with nurses if they're trying to get back into the field. This can kind of be a way to do that because they can kind of use this as a way to get their license back. This is a little look at what a CQE can do versus what it can't do for people utilizing this option. They can relieve certain collateral consequences for criminal convictions like we discussed, like bars to certain types of employment or professional licenses. They can create immunity for negligent hiring liability for employers and provide some tax benefits to employers as well. So it's creating an environment for some employers to want to hire these individuals. They do not seal or expunge, they do not seal or expunge the record. So we want to make that very clear. They do require, and they do require an employer to hire that person. They don't automatically give that person that job. They do not remove barriers for federal or out-of-state offenses. Certificates of qualification for housing. CQHs can remove barriers to housing, but essentially allow the court to review or investigate a person to make sure they are a good candidate for housing, which in turn signals to landlords that they have the court stamp of approval. So CQHs do not order a landlord to rent to someone, but do make it easier. Here, there are two ways to apply. First, while someone is incarcerated or on community control, through the Ohio Department of Rehabilitation and Corrections, or the second way is as a direct application to local common pleas court. For pardons, there's the expedited pardon option. It has all the benefits of sealing and expungement. The records can be automatically sealed based on receiving a pardon, and it is only about a 6 to 12-month process. It's really quick. The information for that can be found at the ohioexpeditedpardon.org website. And under a traditional pardon, it's essentially the same, except it takes at least a year and it's much less likely to be successful. The records are sealed based on the pardon, but it's not an automatic process, and someone must be otherwise eligible, so it does not alleviate any remaining sanctions related to that conviction. Driver's licenses. Any questions about the few we've gone through?
For everyone who has to jump off, I know we only timed it for a half an hour. I am recording it, so I can send you the link to that if you're not able to stay on. Or if you have any questions before she gets started, go ahead and do that. For everyone else, we'll go ahead and let her finish her presentation because I think this information is great to have, but wanted to let you know that I am recording it so I can send it out when we're done if you have to jump off.
Okay. Here's a list of common reasons for license suspensions. I don't think I'll read these to you. I'm sure you all are familiar with some of the ways people can get their license suspended. And we'll talk about a few going forward. Here's how you can check when someone's license status. You can log on through the BMV. You can do it too if you have enough of people's credentials. Or if you're sitting down with a client, you can walk through it with them. That can be very helpful. We do that all the time. When determining driver's license suspension status, it's important to look at what issues are on the table. There will most likely be both court issues and BMV issues. What are court issues? Well, the court can impose suspensions for traffic violations or drug or alcohol offenses. The length of court suspensions are court issues, and the length of that suspension is determined by the judge. Court suspensions and fines must be resolved directly through the court and are not through the DMV, and must be resolved before dealing with the BMV issues. As you're working through the reinstatement process, there is a correct order of operations here, unfortunately. So we like to make sure that people know what they're doing before they jump into this process. We walk through this when we pull up the BMV report. It's really tricky. This is a many-step process. So we kind of mark it with circle of priorities, and we would advise that if you guys are working with people to do that as well. Court first, BMV second. For BMV issues, the BMV can impose insurance-related suspensions, and they can also do 12-point suspensions and other types. The length of those suspensions is determined by Ohio law, and the BMV can impose reinstatement fees, and their suspensions and reinstatement fees must be resolved with the B&B directly. Sometimes these fees are quite large, but they do offer payment plans for people. Limited driving privileges. The process for license reinstatement really is daunting and often takes a lot of time and money. This alternative really is a good option sometimes. It's a more limited scope, and it does meet some people's immediate needs to drive. These allow a person to drive for specific purposes at certain times into specific places like schoolwork or medical needs. A court that issues a suspension can grant driving privileges so long as a license is not expired and the driver is in compliance with all other suspensions. For B&V suspensions, the driver can apply for privileges in the municipal court in their county of residence. This is a quicker option for people who have a more urgent need to drive. It's also a good option if they really do just need to drive to and from work or can make other arrangements for their driving needs. Sometimes the requirements to get a license reinstatement may actually not just be in the best interest of that person, and they really just need to get to whatever appointments they have and can make this work for them. For reinstatements, common reinstatements we see are remedial driving courses, retesting for licensing exams, SR22s or bond, and those reinstatement fees that we've discussed. The amnesty program. This is a program that reduces or completely waives the fees on eligible offenses. Fees can be waived if drivers qualify for SNAP, Medicaid, OWF, SSI, or VA pension. Otherwise, the fee is 50%. You pay and the other fees is covered. Applicants are only eligible for the amnesty program once ever, and they are not offenses involving drugs, alcohol, or deadly weapons are not eligible or available. In this application, it's submitted directly to the B&B. Okay, here again is our intake line. We also accept applications online. Clients who apply online typically will get a call back from our intake staff. I believe it's within a week, but don't quote me on that. I'm not on intake, so I don't necessarily know that timeline. But I know they try to get to you as quick as possible. And then at this point, any other questions? I have time to answer them. So whoever wants to stay on, you can also reach me. That's my direct line and email. So any questions, and of course, we'll send this presentation. Otherwise, if you have to jump off, thanks for letting me speak with y'all today, and I hope you have a great weekend.
Thank you.
Of course.
Okay, thank you. I may reach out to you directly with some other questions, or to set up additional trainings.
Okay.
But otherwise, I really appreciate you helping us out and going through this with us.
No problem. Yeah, and I'll send you the presentation. Yeah, and thanks for having me.
Yeah, thank you.